It is submitted by learned counsel for the appellants that the deceased was 42 years of age at the time of accident staff. The deceased was a government assistant teacher staff. His income was considered by the tribunal to be rupees 31,090 per month staff. It is further submitted that the tribunal granted future loss of income of the deceased staff. The future loss should be granted as per Uttar Pradesh Motor Vehicles within bracket 11th Amendment bracket out rules comma 2011 and also as per decisions of Supreme Court in Sarla Verma versus Delhi Transport Corporation comma under bracket 2009 6 SCC 121 colon 2009 under bracket 3 AWC 2138 under bracket SC and Sri K.R. Madhusudan and others versus administrative officer and another comma under bracket 2011 4 SCC 689 colon 2011 under bracket 2 AWC 1820 under bracket SC star. It is further submitted that the amount granted under non-pecuniary damages is on the lower side and same should be computed and granted as per the decision titled National Insurance Company Limited versus Pranay Sethi and others, 2017 0 Supreme under bracket SC 1050 colon 2017 under bracket 6 AWC 6477 under bracket SC star. It is further submitted that the deduction towards personal expenses of the deceased should be 1/3 or 1/4 as he was survived by widow, mother and 2 sons star. It is submitted by learned counsel that tax is calculated wrongly and the deduction of income tax by adding future prospect is against legal position of law and is bad staff para. It is further submitted that the deceased was not a tortfeasor despite that tribunal has deducted compensation which could not be done as it is settled law that amount cannot be deducted if the person sustained injuries or death occurred for no fault of his staff para. The counsel for the appellants has submitted that from the factual data, this court can call out that the accident occurred on 27/6/2014 causing death of Uday Veer who was 42 years of age at the time of accident start. The tribunal has assessed income to be rupees 31,090 per month even if not disturbed by this court as rupees 580 is the deduction which includes rupees 500 as tax star. It is submitted that the deceased was in the age bracket of 40 to 50 and had a permanent job, hence addition of 30% of the income may not be disturbed but is required to be added not only for the purpose of deduction of income tax but for actual calculation of compensation not done by tribunal or on erroneous findings recorded based on whims and not on precedents but against settled legal principles and added in view of the decision of the apex court in Pranay Sethi under bracket supra star. The amount under non-pecuniary heads should be at least rupees 1 lakh in view of the decision in Pranay Sethi under bracket supra star. The amount rounded is up to rupees 1 lakh as 10% of rupees 70,000 would have to be added every 3 years and therefore we add the same star. In view the facts and circumstances of the case, this court feels no interference is called for as far as deduction of personal expenses is concerned staff para. The vehicle which is involved in the vehicular accident were a jeep oblique car not driven by deceased Uday Veer staff. The appellant has not challenged the decision on negligence but is challenged is deduction of compensation payable to heirs of non-tort feasor staff.